am a lawyer, but I am not necessarily your lawyer. The materials discussed in this podcast are for informational purposes only and should not be deemed legal advice. If you have a specific legal question according to your circumstances, then I encourage you to speak with an attorney licensed in your jurisdiction. Welcome back to another edition of Ag Law Today. We've got a special guest. So across the line from me, from Indiana, we've got Brianna Schroeder in the house. So Brianna, why don't you introduce yourself to our listeners? Tell us about you, where you're from, what you're doing, and your involvement in agriculture law.
Yeah, thanks, Carrie. My name is Brianna. I grew up just outside of Decatur, Indiana. So I grew up in the northeast corner of the state on a little family farm. I went to undergrad up in Wisconsin and then came back to Indiana for law school. So I kind of just hover around the Midwest, it seems. And I have now worked in Indianapolis for the majority of my legal career. I had a short stint downtown Chicago before realizing that I am not meant to be in such a big city. So I am now an attorney at Jansen Agricultural Law here in Indianapolis. My practice focuses on really just representing ag producers, so farmers, businesses that are in the ag space, any kind of ag entity, whether it be then litigation, land use. We do a lot of transactional contract work. And, our goal is, of course, to make sure that our ag producers here in the Midwest and beyond are situated as best they can to produce food for the rest of the world. So that's kind of a snapshot, I guess, at what our business is.
That's great. So how is life in Indianapolis? So I actually, growing up, had a miniature city crush on Indy. My very first experience there, I was there for a volleyball tournament, believe it or not. And I remember thinking that downtown Indy was so cute, how they had those walkways like with the buildings and everything. So
it's all connected, right?
16-year-old Carrie thought that was so, awesome. Anyway, so how is Indianapolis?
I love Indy because it scratches the itch for the big city benefits. We've got live music and professional sports and good restaurants. But I live in the city, and in 10 minutes, maybe 15 minutes, I can be driving through cornfields. So I kind of like that balance. I live downtown Chicago, which was fun for a minute. You'd walk out my balcony and the Sears Tower was on your left, and that was kind of cool, but a 1-bedroom condo is pretty small. So we were happy to move back down here to Indianapolis.
Get some more space. Yes, I started Rinker Law in a studio apartment on the Upper East Side. So, small spaces can, get to you after a while. So I get that. So today we're talking about all things COVID with contracts and force majeure, which has been a big hot topic over the last 6 months or so during this pandemic. So Brianna, why don't we just start with the basics? What is force majeure?
So there's I'm going to speak kind of in non-legalese because I think it's just easier to understand. Force majeure is a provision people can put in contracts that provides an excuse for one or the other party to not perform their contractual obligation. So normally, if two parties have a contract, Carrie and Brianna have a contract, and Carrie breaches that contract by not doing what you're supposed to do, normally I've got rights to come back against you. Force majeure is a way that you could say, look, Brianna, I have a defense here. The reason I didn't perform what I was supposed to do under the contract is because of this force majeure event. And kind of in a nutshell, force majeure is when one of the parties' performance is made either impossible or it is hindered or prevented from occurring due to forces outside of either party's control. So something that you didn't cause is preventing you from doing what you're supposed to do under the contract.
Yeah, I like the way that you phrase that, because I feel like a common confusion is that force majeure doesn't like just give you a reason to get out of the contract. It's more of like a defense or an excuse, right?
Yeah, that's the way to think of it. It's, because if you and I have a contract that you're going to build me widgets, and one day you say, hey, Brianna, I know I'm supposed to get you 100 widgets this month. I just don't think I'm going to do it. I could have a lawsuit against you. I could file suit against you. But it's different if you say, Brianna, I can't get you those 100 widgets because there was a force majeure event. And maybe in that case, it was a natural disaster, an act of God. If you read these clauses, some of the language is, it's big language, right? It's, severe acts of nature and God and things that we can't control. And, at least in my experience, up until COVID, I kind of feel like a lot of these clauses, it's like boilerplate. Like it just gets thrown in a contract. It's usually not one of the terms people are haggling over. You just agree to it. Oh yeah, whatever you got in there, it's a placeholder, it's fine. Where now all of a sudden I feel like people are really looking at that clause and going, oh, this matters.
Yeah, I think to your point, I feel like only one time in my whole life was I ever negotiating the force majeure clause, right? And I guess my client was anticipating all sorts of disasters, but he did not anticipate a pandemic. So I'm curious, Brianna, is there case law that would say that infectious diseases and viruses and things would fall into an act of God? Because I think that even that alone is kind of murky.
Yeah, an act of God is crazy murky, right? So what it seems most of the case law in the U.S. generally seems to say that the first thing we look at is really specifically the language that you picked to use in that contract. And there are ones out there that list pandemic or infectious disease or government orders and regulations. So I think an act of God that's too broad and too vague. Most courts are going to look at these provisions and really narrowly construe them. And so the cases I've seen, and there's very few cases that are starting to come out on COVID, but what they seem to be looking at, either you have to have specifically said pandemic, infectious disease, something along those lines, or what seems to be happening more frequently is if the provision says if your non-performance is caused by a government order or regulation, and then that's more likely, a court is more likely to consider that a potential appropriate force majeure event.
Yeah, man, you're having me think about every contract I've ever, drafted. Like maybe I need to redo this clause now. So I'm hoping that my clients are listening to this or calling me. So what do you do if a client calls you up and it's like, I have a potential problem, so-and-so is trying to get out of the contract, or they're raising, force majeure as a defense? What's sort of the step-by-step approach?
Right. So the first thing, obviously, is since this is a contract issue, you can't just go straight to the case law. You got to pull out the actual contract because the actual words matter. So force majeure A, maybe it applies, but in contract B, it doesn't apply because it's worded differently. So the first thing I think you do is you go straight to the language to see exactly what type of events are listed. And sometimes some provisions will include the element of unforeseeability. In other words, Is it a force majeure event? It has to be something that neither one of us could have foreseen. And there's a lot of case law out there that talks about that. But then I think what's also important to check, especially when you were talking about COVID, some force majeure events have specific language that talk about like an economic downturn or a market effects, market forces. And some of them will say either specifically, market forces count. If supply or demand crashes, that counts. By and large, that doesn't happen. And I think what's interesting is most cases from New York to Indiana, Minnesota, most cases, and Delaware's got some too, most cases hold that without that really specific language about the market, that a simple economic downturn or a market reduction is not enough to constitute a force majeure event. So I think that's going to come into play here in the COVID cases that we're starting to see churn up.
Yeah, also, and like to that point, Brianna, I mean, like there could just be an aftermath of the economic downturn, for a long time because of this. And then also just that term economic downturn is in itself so ambiguous. Like, what does that mean exactly? So what a mess this all is. But at the same time, is also, I think for me, even just as a business owner, what COVID has done to me is that none of us can really predict the future. I mean, I just got back from court and I was wearing a face mask. Everybody there was wearing a face mask. Never in a million bazillion years did I ever think it was going to happen, right? And I think that we all need to be prepared for the quote unforeseen, right? And I think that that's great language to include in that. But Brianna, I don't know, how do you feel though about folks in agriculture and their willingness to really think these issues through with contracts? I know that a lot of folks in agriculture, it's very much a handshake culture. I've struggled, even sometimes with the farmers getting basic terms in writing, much less the nuances of a force majeure clause. So what are your thoughts on that?
Well, and I think like you make an awesome point because I mean, COVID life is crazy, right? And I don't think it's going away tomorrow. So this is not, in my mind, just a situation where we can look to the past and say, well, geez, I wish the contracts I negotiated for the last 2 years included more specific force majeure language. I mean, I feel like contracts negotiating today, I mean, I don't know, what's the winter going to look like? What's next year going to look? I just don't think we know. So I think it's all still for very, very present for contracts we're negotiating now and in the future. This is all still really relevant. And I hear you. I mean, I have clients that will say, okay, fine, I'll do a written contract, but make it 1 page. Can't be more than 1 page. Because otherwise, and I get this, I mean, you and I have been doing business an awful long time. And then one day I show up and I say, Carrie, I want to keep doing things the way we've been doing them. But now I talked to my lawyer and she said, here's a 15-page agreement you have to read and sign. I get that. That's hard. And, I always tell my clients, my goal with a contract is we can draft it and hopefully we never need it, right? Hopefully everything goes great and it's a great business relationship and everybody wins. But in those small percentage of cases where, surprise, something goes wrong, well, then you need to have that written backstop. Because otherwise it's me saying you agreed to pay me $5 a widget and you saying, no, it was going to be $1 a widget. And, where does that leave us?
Yeah, exactly. And I think getting contracts in writing is not about trusting the other person. It's about clarification of the material issues, but also how are you going to address things that are out of your control, hence the force majeure clause. What happens if there's a government taking? What happens if there's a flood, a fire, a freaking pandemic? Like there's so many things that can happen that has nothing to do with your relationship with the other party, but how are you going to deal with that if that happens? And I think that that's what we're dealing with now.
Exactly. I think part of it is not even the end result of the written contract. It's the process of getting there. It's putting in a provision and having the other side say, "Whoa, you think that's important, or you think that's part of our deal? Oh yeah, I always thought this was a 5-year deal." And whatever the result is, then at least we've talked about it and got it putting down on paper. I think there's a lot of situations in COVID now where we're seeing these government regulations that may or may not constitute force majeure. I mean, if you are a restaurant and the government of Illinois says all restaurants are closed, period. I mean, does that hinder your ability to fulfill a contract? Maybe, maybe not. Well, what if it just says restaurant, you're restricted to 50% operations?
Mm-hmm.
Does that hinder your ability to pay your rent, for example? I mean, these are the questions I think that are being raised in courts across the country right now.
Yeah, no, absolutely. So what do you tell folks out there who are maybe looking at a contract and they're like, I'd really like to get out of this. I'd like to maybe depend on the force majeure. You think that they need to look at the black and white letters there and see what it says?
Yeah, I think that's step one. I think if you have a way to tie your inability to perform to a government regulation or a bigger issue than just the market, I think you will be better off. I think if you're just relying on, the economy took a little dip there for a minute, I don't think that's going to be enough. The other thing to think about is usually these provisions usually what they call for is basically a temporary period, that this force majeure period of non-performance isn't going to be forever. A lot of times they'll say, there's a certain period of time that exists, and then after that, maybe the parties have rights to renegotiate or terminate or just go back to their regularly scheduled program. So I think if I had a client that said, "Geez, Brianna, I gotta get out of this. I can't do this. I can't perform here," one of the first things I would probably say to them is, based on the language, do we think there's a possibility? Can you get a month to get yourself in order? Can you perform at a lower, instead of giving me 100 widgets a month, could you make 50 widgets a month? What's your business relationship with the other party? Is it something where there's going to be room for negotiation, or is this, this is what it is, and if we can't do this, we've got trouble? And then also, as I mentioned, tying it to something other than market forces, because I just don't think that's going to be enough.
Yeah, interesting. So how would you compare COVID to other potential force majeure events?
Yeah, there's a lot of them that I've read about and that I've seen in my practice are much more technical. There's a big case here in Indiana that dealt with if we had a contract to do something, we all agreed we were going to do this, and suddenly, in order for you to perform your role, you needed to have an outside party audit you. And for whatever reason, that audit couldn't occur. And there's this case, it has to do with the VA hospital needing to get approval, and they needed to have an audit done. And so the question in the case ended up being, is the inability to get this audit, does that count? So it's way more technical. And the court looked at, it was totally unforeseen by both parties that such an audit would ever come up. And so the court eventually held that, yeah, that is enough to excuse non-performance because nobody foresaw it. It was totally outside either of their realms of control. So, some of them are real technical. Some of them are maybe what we would more think of act of God, hurricanes down on the southeastern coast, blizzards, power outages, things like that. And I think that's what, maybe more easily comes to mind. There are some old cases that deal with major strikes, if there's a workers' strike that prevents something from happening. Now we're living in a pandemic, and that's not something I think people have really considered putting into most of their contracts.
Yeah, I mean, what's the saying? Expect the unexpected. And I feel like that's what we have to do now. And I feel like lawyers are such doomsdayers, right? Like we're
Mhm.
always like trying to like think about like the worst case scenario and like what would happen and would you be covered? But I feel like if 2020 has taught us nothing else, that we need to start thinking this way with contracts.
Right. I think that is maybe that's the only good to come out of 2020 is a good contracts lesson, and that a clause like this that I think a lot of times gets buried on, you know, section 14.2 of page 7. Maybe it's I think it's worth another look more than just, hey, whatever the boilerplate is, that works for me, because now we're seeing it can have very real world consequences to farmers, to ag businesses. This is suddenly a daily concern for a lot of people out there.
Yeah, great points. So, Brianna, how can folks find you? Do you have a website, email? What's your contact information?
Yes. So the website's real easy. It's aglaw.us, and that's it. My email, and I'm pretty good at getting back on email. I'll spell it. It's schroeder at aglaw.us. And, we're here in Indianapolis. We are located in the Indiana soybean building, which is kind of a fun place to be because we've got the pork folks, beef, corn, soybean, aquaculture. We're all in the same building, which is, helpful a lot of times for some of the work we do. So
Oh, that's
happy
awesome.
to follow up with questions. Our number is 317-855-9920. And that works too. But, these day and age, email sometimes seems to be the easiest.
And are you on social media? Can folks find you on any of the social media platforms?
Yes, I have my Twitter account is at Schroeder Indy. And I think I've got a link to it on my page. And we actually do a lot of blogging here in our firm just because we feel like, we get these ideas that we hope can help our clients, even if it's something they weren't thinking of, maybe it reminds them of something new. So we've got a pretty good feed of blog titles and blog articles on our website too that people can pull up and get themselves a little free dose of ag information.
So I've got two last questions for you. The first one is, and I know you're located specifically in Indiana, but we've got folks all over the country listening to this podcast. So if our listeners are looking for counsel, closer to them, perhaps somebody who understands agriculture and knowledgeable about contracts and force majeure clause, what would be your suggestion on how to find the right person?
I think a great resource is the American Agricultural Law Association, or ALA. And if you just Google that, American Ag Law Association, it's a list of attorneys across the country, and I think maybe into Canada as well, that practice specifically in the ag law space. Otherwise, I'm always happy if I've got all kinds of, we've got clients from California to the East Coast. And usually if we can't help you because you've got to be licensed, say in Nebraska or something, we can usually refer somebody to a friend out that way.
Then my last and final question is, besides looking differently at contracts, what would be another silver lining for you with this pandemic? Any lessons you think?
Wow, that's a hard one. I would say, what is a silver lining, both professionally and otherwise, is I do think we've been forced to slow down. And for me, that can be really hard to do. But whether it is with my clients and in work situations or at home with our families, I feel like you just got to slow down a little bit. And as much as we may want 2020 to just fly by, we've got to take a deep breath and, maybe take an extra walk or something, because I think the silver lining is slowing down everything.
Yeah, I think it was like God's way of forcing that to happen in a way, right? So
Absolutely.
anyway, well, thank you so much. Looking forward to having you on the podcast again.
Thanks, Carrie.